Now let's talk about Article 13 of the Indian Constitution. Beginning with Article 13, Clause 1. If there is a law, for example, this law was in operation prior to 1950. Why 1950? When Constitution was enacted. So any law which was in operation prior to the commencement of this Constitution, if that law is inconsistent with the fundamental rights which are given by the Constitution to the people of this country, if those laws or any part of that law is against fundamental rights provided by Part 3 of the Indian Constitution, that law is unconstitutional. That means Article 13 Clause 1 talks about that any law which was in operation prior to the commencement of this Constitution, but once we have given this Constitution to the people of this country and we have given them a list of fundamental rights, if any part of that law or the whole law as well, if that law or a part of that law is against Part 3 of the Indian Constitution, against the fundamental rights provided by the Constitution of this country, that law shall be declared as unconstitutional and void. That means no law can violate the fundamental rights provided by the Constitution of this country. Article 13, Clause 2. The state shall not make any law, stress on the word law, the state shall not make any law which takes away or abridges means which reduces the rights conferred by this part, and any law made in contravention of this clause shall, to the extent of such contravention, be void. What does that mean? That means Parliament cannot make a law which can deprive me of my fundamental right. And if Parliament has made a law which deprives me of my fundamental right, that law will be unconstitutional and void. That means Article 13 Clause 1 talks about pre-republic law or pre-constitution law. That means a law which was there prior to the commencement of this Constitution. If that law violates fundamental rights, unconstitutional. After the commencement of this Constitution, if the Parliament decides to make a law, or if the legislature decides to make a law which violates fundamental rights provided by Part 3 of the Indian Constitution, that law shall also be unconstitutional and void. When we say, and any law made in contravention of this clause shall, to the extent of such contravention, that means we follow doctrine of severability. What does that mean? That means if a law has 10 provisions, for example, this is a law X, it has 10 provisions, 1, 2, 3, up to 10. Now the entire law is not against fundamental rights, but only 2 provisions are against fundamental rights. What does that mean? Should we strike down the whole law as unconstitutional? No. We should strike down only those parts, in this case 1 and 2. If these parts are against fundamental rights, only these 2 provisions will be struck down by the courts. That means doctrine or theory of severability. We will sever, we will cut down only those provisions of that law which are against the Constitution, not the whole law. If there are some parts of a law which are unconstitutional, only those parts will be deleted, the rest will remain as such. That means Article 13 Clause 2 talks about no law can be made which can deprive an individual, which can snatch fundamental rights from a citizen. And Article 13 Clause 3 provides for the definition of this law. What is this law that we are talking about? In this case, the definition says that law includes an ordinance, order, bylaw, rule, regulation, notification, custom, usage, having in the territory of India the force of a law. But when you look deeper at Article 13 Clause 3, there is no mention of Constitutional Amendment Act. What are we talking about? Article 13 Clause 1. If there was a law which was present, which was in operation prior to the commencement of this Constitution, if that law is against the fundamental rights, that law shall be declared as unconstitutional and void. That means that law is unconstitutional, no matter what. But after the commencement of the Constitution, if Parliament decides to make a law which wants to snatch or abridge a part of fundamental right, that law also will be unconstitutional. And what is the definition of this law? Law means ordinances, rules, regulations, notifications. But in this definition of law, there is no mention of Constitutional Amendment Act. That means only by amending the Constitution, only by the amendment of the Constitution within the meaning of Article 368. That means there exists an Article 368 which talks about how you can amend this Constitution. That means only by amending the Constitution by Article 368 can you deprive an individual of his fundamental right. This was the position for a number of years after the commencement of the Constitution. When Constitution was amended for the first time in 1951, Article 15 of the Indian Constitution was amended. We'll talk about that later. Article 15 was amended. Article 15 deals with fundamental rights. How can you amend fundamental rights? Or how can you abridge fundamental right? Because Article 13 Clause 2 states that no law can deprive an individual of that fundamental right. But the position was, when this particular amendment was challenged in the Supreme Court said this is constitutional. Why? Because law within the meaning of Article 13 Clause 3 does not include a Constitutional Amendment Act. That means only by amending the Constitution you can snatch a fundamental right. But this position changed. This position changed in 1967. In 1967, in a very famous Golaknath case, the Supreme Court said, law includes a Constitutional Amendment. But to provide a remedy to this Supreme Court judgment, Parliament decides to amend the Constitution. Parliament decides to amend Article 13 of the Indian Constitution, inserting Article 13 Clause 4. Nothing in this article shall apply to an amendment of the Constitution made under Article 368. This was added by 24th Constitutional Amendment Act 1971. That means, in 1951, when Supreme Court said law does not include Constitutional Amendment Act, that means only by amending the Constitution you can snatch a fundamental right. But then in Golaknath case, Supreme Court said law includes a Constitutional Amendment Act. That means even by amending the Constitution by Article 368, you cannot snatch the fundamental rights of the citizens. There was a confusion. To rectify this confusion, Parliament enacted 24th Constitutional Amendment Act, stating nothing in this article shall apply to an amendment of the Constitution within the meaning of Article 368. That means only by the amendment of the Constitution by Article 368 can you snatch a fundamental right or abridge a fundamental right. That's the position today. That means Article 12, definition of the state, Article 13, which talks about you can deprive an individual of his fundamental right, but only by a Constitutional Amendment Act. So you understood these two articles? Now, if you understood these two articles, let's jump into right to equality. And let's talk about Articles 14 to 18 of the Indian Constitution, which talks about 5 very beautiful articles, very beautiful fundamental rights enjoyed by the citizens of this country.